ओके, तो आपसे हम कोशिश करेंगे कि एक दिन में जितना टारगेट होगा वो एक ही वीडियोस में कंप्लीट करेंगे। यानी मान लो पॉलिटी का एक दिन का जो टारगेट है वो एक ही वीडियोस में कंप्लीट करेंगे, वरना मैं रेस्ट ज़्यादा ले रहा हूँ। कल मैं एक ही चैप्टर पढ़ के थोड़ा रेस्ट लेने के चक्कर में पूरा रात सो गए। ठीक, तो चलिए वाइस प्रेसिडेंट से हम स्टार्ट करेंगे। ये काल का टारगेट है और ये गवर्नर ये वाला भी स्टार्ट करेंगे, मतलब पढ़ेंगे आज। ठीक है, वाइस प्रेसिडेंट एक ही वीडियो में, ज़्यादा नहीं है, पेजेस बहुत कम है। द वाइस प्रेसिडेंट ऑक्युपाइज द सेकेंड हाइस्ट ऑफिस इन द country. He is accorded a rank next to the president in the official warrant of precedence. This office is modeled on the lines of the American vice president. Okay. Election. The vice president, like the president, is elected not directly by the people but by the method of indirect election. He is elected by the members of an electoral college consisting of the members of both houses of parliament. Thus, this electoral college is different from the electoral college for the election of the president in the following two respects. It consists of both elected and nominated members of the parliament. In the case of president, only elected members. It does not include the members of the state legislative assemblies. In the case of president, the elected members of the state legislative assemblies are included. तो ध्यान से पढ़िएगा. Explaining the reason for this difference, Dr. B.R. Ambedkar observed, the president is the head of the state and his power extend both to the administration by the center as well as to the states. Consequently, it is necessary that in his election not only members of parliament should play their part, but the members of the state legislature should have a voice. But when we come to the vice president, his normal functions are to preside over the council of states. It is only on a rare occasion, and that too for a temporary period, that he may be called upon to assume the duties of the president. That being so, it does not seem necessary that the members of the state legislature should also be invited to take part in the election of the vice president. But the manner of election is same in both the cases. Thus, the vice president's election, like that of the president's election, is held in accordance with the system of proportional representation by means of the single transferable vote, and the voting is by secret ballot. All doubts and disputes in connection with election of the vice president are inquired into and decided by the Supreme Court, whose decision is final. The election of a person as vice president cannot be challenged on the ground that the electoral college was incomplete, that is, existence of any vacancy among the members of electoral college. If the election of a person as vice president is declared void by the Supreme Court, acts done by him before the date of such declaration of the Supreme Court are not invalidated, that is, they continue to remain in force. Qualifications, oath and conditions. Qualifications. To be eligible for election as vice president, a person should fulfill the following qualifications. He should be a citizen of India. He should have completed 35 years of age. He should be qualified for election as a member of the Rajya Sabha. He should not hold any office of profit under the union government or any state government or any local authority or any other public authority. Okay. But a sitting president or vice president of the union, the governor of any state, and a minister for the union or any state is not deemed to hold any office of profit and hence qualified for being a candidate for vice president. Okay. Further, the nomination of a candidate for election to the office of vice president must be subscribed by at least 20 electors as proposers and 20 electors as seconders. Every candidate has to make a security deposit of 15,000 in the Reserve Bank of India. अच्छा, तो ये वाइस प्रेसिडेंट जो बनेगा उसका सिक्योरिटी डिपॉजिट नहीं है, ये है जो कैंडिडेट उसको सब्सक्राइब करेगा, यानी प्रपोजर्स एंड सेकेंडर्स वो सबको देना पड़ेगा, तो बहुत पैसा हो जाएगा भाई। Then oath or affirmation. Before entering upon his office, the vice president has to make and subscribe to an oath or affirmation. In his oath, the vice president swears to bear true faith and allegiance to the Constitution of India and to faithfully discharge the duties of his office. The oath of office of the vice president is administered by the president or some person appointed in that behalf by him. Conditions of office. The Constitution lays down the following two conditions of the Vice President's office. He should not be a member of either House of Parliament or a House of the State Legislature. If any such person is elected Vice President, he is deemed to have vacated his seat in that House on the date on which he enters upon his office as Vice President. He should not hold any other office of profit. Term and vacancy. Term of office. The Vice President holds office for a term of 5 years from the date on which he enters upon his office. However, he can resign from his office at any time by addressing the resignation letter to the President. He can also be removed from the office before completion of his term. A formal impeachment is not required for his removal. He can be removed by resolution passed by a majority of all the then members of the Rajya Sabha and agreed to by the Lok Sabha. This means that this resolution should be passed in the Rajya Sabha by an effective majority and in the Lok Sabha by a simple majority. It must be noted here that the effective majority in India is only a type of special majority and not a separate one. Further, this resolution can be introduced only in the Rajya Sabha and not in the Lok Sabha, but no such resolution can be moved unless at least 14 days advance notice has been given. Notably, no ground has been mentioned in the Constitution for his removal. The Vice President can hold office beyond his term of 5 years until his successor assumes charge, same as President. He is also eligible for re-election to that office. He may be elected for any number of terms. Vacancy in office. A vacancy in the Vice President's office can occur in any of the following ways: on the expiry of his tenure of 5 years, by his resignation, on his removal, by his death. Otherwise, for example, when he becomes disqualified to hold office or when his election is declared void. When the vacancy is going to be caused by the expiration of the term of the sitting Vice President, an election to fill the vacancy must be held before the expiration of the term. If the office falls vacant by resignation, removal, death or otherwise, then election to fill the vacancy should be held as soon as possible after the occurrence of the vacancy. The newly elected Vice President remains in office for a full term of 5 years from the date he assumes charge of his office. Powers and functions. The functions of Vice President are twofold. He acts as the ex officio chairman of Rajya Sabha. In this capacity, his powers and functions are similar to those of the Speaker of Lok Sabha. In this respect, he resembles the American Vice President. So, ex officio chairman of Rajya Sabha is Vice President. He resembles like Speaker of Lok Sabha and American Vice President, who also acts as the chairman of the Senate, the upper house of the American legislature. ये अमेरिका की बात हो रहा है, अमेरिकन वाइस प्रेसिडेंट की. 2. He acts as president when a vacancy occurs in the office of the president due to his resignation, impeachment, death or otherwise. He can act as president only for a maximum period of 6 months, within which a new president has to be elected. Further, when the sitting president is unable to discharge his functions due to absence, illness or any other cause, the vice president discharges his functions until the president resumes his office. While acting as president or discharging the functions of president, the vice president does not perform the duties of the office of the chairman of Rajya Sabha. During this period, those duties are performed by the deputy chairman of Rajya Sabha. The Constitution has not fixed any emoluments for the Vice President in that capacity. He draws his regular salary in his capacity as the ex officio chairman of the Rajya Sabha. In 2018, the Parliament increased the salary of the chairman of Rajya Sabha from 1.25 lakh to 4 lakh per annum. Earlier in 2008, the pension of the retired vice president was increased from 20,000 per month to 50% of his salary per month. In addition, he is entitled to daily allowance, free furnished residence, medical travel, and other facilities during any period when the vice president acts as president or discharges the functions of the president. He is not entitled to the salary or allowance payable to the chairman of Rajya Sabha, but the salary and allowances of the president. Indian and American vice presidents compared. Though the office of the Indian vice president is modeled on the lines of the American vice president, there is difference. The American vice president succeeds to the presidency when it falls vacant and remains president for the unexpired term of his predecessor. The Indian vice president, on the other hand, does not assume the office of the president when it falls vacant for the unexpired term. He merely serves as an acting president until the new president assumes charge. From the above, it is clear that the Constitution has not assigned any significant function to the Vice President in that capacity. Hence, some scholars call him His Superfluous Highness. This इतना सैलरी क्यों पे करते हैं इन लोगों को फिर? This office was created with a view to maintain the political continuity of the Indian state. Okay. Now articles related to Vice President at a glance. तो ये सर आर्टिकल्स के बारे में बात किया गया है. तो ये चैप्टर बेसिकली यहाँ पर ख़त्म होता है. अब हम चलेंगे चैप्टर नंबर 30 जो कि गवर्नर के बारे में है. तो ये है चैप्टर गवर्नर. ओके, पढ़ेंगे इसको. द कॉन्स्टिट्यूशन ऑफ इंडिया envisages the same pattern of government in the states as that for the center, that is a parliamentary system. Part 6 of the Constitution deals with the government in the states. Articles 153 to 167 in Part 6 of the Constitution deal with the state executive. The state executive consists of the governor, chief minister, the council of ministers and the advocate general of the states. वो सेंट्रल में क्या था? प्रेसिडेंट था, प्राइम मिनिस्टर था, काउंसिल ऑफ मिनिस्टर्स था, कैबिनेट मिनिस्टर्स और अटॉर्नी जनरल था. Thus, there is no office of vice governor in the state like that of vice president at the center. बट यहाँ पर स्टेट में कोई वाइस गवर्नर नहीं होते. The governor is the chief executive head of the state, but like the president, he is a nominal executive head, titular or constitutional head. The governor also acts as an agent of the central government. Therefore, the office of governor has a dual role. Usually, there is a governor for each state, but the 7th Constitutional Amendment Act of 1956 facilitated the appointment of the same person as a governor for 2 or more states. Appointment of governor. The governor is neither directly elected by the people nor indirectly elected by a specially constituted electoral college, as is the case with the president. He is appointed by the president by warrant under his hand and seal. In a way, he is a nominee of the central government, but as held by the Supreme Court in 1979, the office of governor as a state is not an employment under the central government. It is an independent constitutional office and is not under the control of or subordinate to the central government. The draft constitution provided for the direct election of the governor on the basis of universal adult suffrage, but the Constituent Assembly opted for the present system of appointment of governor by the president because of the following reasons. The direct election of the governor is incompatible with the parliamentary system established in the states. The mode of direct election is more likely to create conflicts between the governor and the chief minister. The governor being only a constitutional nominal head, there is no point in making elaborate arrangements for his election and spending huge amount of money. The election of a governor, यहाँ पर तो बात होती है मानी कि the election of a governor would be entirely on personal issues. Hence, it is not in the national interest to involve a large number of voters in such an election. Okay. An elected governor would naturally belong to a party and would not be a neutral person and an impartial head. The election of governor would create separatist tendencies and thus affect the political stability and unity of the country. The system of presidential nomination enables the center to maintain its control over the states. The direct election of the governor creates a serious problem of leadership at the time of general election in the state. The chief minister would like his nominee to contest for governorship. hence a second-rate man of the ruling party is elected as governor. Therefore, the American model, where the governor of a state is directly elected, was dropped, and the Canadian model, where the governor of a province state is appointed by the Governor General Center, was accepted in the Constituent Assembly. The Constitution lays down only two qualifications for the appointment of a person as governor. These are: he should be a citizen of India, he should have completed the age of 35 years. Additionally, two conventions have also developed in this regard over the years. First, he should be an outsider, that is, he should not belong to the state where he is appointed, so that he is free from the local politics. Second, while appointing the governor, the president is required to consult the chief minister of the state concerned so that the smooth functioning of the constitutional machinery in the state is ensured. However, both the conventions have been violated in some of the cases. Now, conditions of governor's office. The Constitution lays down the following conditions for the governor's office. He should not be a member of either House of Parliament or a House of the state legislature. If any such person is appointed as governor, he is deemed to have vacated his seat in that house on the date on which he enters upon his office as the governor. He should not hold any other office of profit. He is entitled without payment of rent to the use of his official residence, the Raj Bhavan. The president Rashtrapati Bhavan में रहते हैं. He is entitled to such emoluments, allowances and privileges as may be determined by parliament, and when the same person is appointed as the governor of two or more states, the emoluments and allowances payable to him are shared by the states in such proportion as determined by the president. His emoluments and allowances cannot be diminished during his term of office. In 2018, the Parliament has increased the salary of the governor from 1.10 lakh to 3.5 lakh per month. इतना हाइक क्यों कर दिया गया था? मतलब इन्फ्लेशन इतना ज़्यादा था. चलो, like the president, the governor is also entitled to a number of privileges and immunities. He enjoys personal immunity from legal liability for his official acts. During his term of office, he is immune from any criminal proceedings, even in respect of his personal acts. He cannot be arrested or imprisoned. However, after giving 2 months' notice, civil proceedings can be instituted against him during his term of office in respect of his personal acts. Before entering upon his office, the governor has to make and subscribe to an oath or affirmation. In his oath, the governor swears to faithfully execute the office, to preserve, protect and defend the constitution and the law, and to devote himself to the service and well-being of the people of the state. The oath of office to the governor is administered by the Chief Justice of the concerned state High Court, and in his absence the senior-most judge of that court available. Every person discharging the functions of the governor also undertakes the similar oath or affirmation. Term of governor's office. A governor holds office for a term of 5 years from the date on which he enters upon his office. However, this term of 5 years is subjected to pleasure of the president. Further, he can resign at any time by addressing a resignation letter to the president. The Supreme Court held that the pleasure of the president is not justifiable. The governor has no security of tenure and no fixed term of office. He may be removed by the president at any time. The Constitution does not lay down any grounds upon which a governor may be removed by the president. Hence, the National Front government headed by VP Singh asked all the governors to resign as they were appointed by the Congress government. Eventually, some of the governors were replaced and some were allowed to continue. The same thing was repeated in 1991 when the Congress government headed by P.V. Narasimha Rao changed 14 governors appointed by the VP Singh and Chandrasekhar governments. The president may transfer a governor appointed to one state to another state for the rest of the term. Further, a governor whose term has expired may be reappointed in the same state or any other state. A governor can hold office beyond his term of 5 years until his successor assumes charge. The underlying idea is that there must be a governor in the state and there cannot be an interregnum. The president can make such provisions as he thinks fit for the discharge of the functions of the governor in any contingency not provided for in the Constitution, for example, the death of a sitting governor. Thus, the Chief Justice of the concerned state High Court may be appointed temporarily to discharge the functions of the governor of that state. तो अगर गवर्नर नहीं रहे तो उसके जो टेम्पररी गवर्नर होगा कौन होगा? यानी इंचार्ज कौन होगा, चीफ जस्टिस ऑफ द concerned state high court, chief justice of the concerned state high court. Powers and functions of governor. A governor possesses executive, legislative, financial and judicial powers more or less analogous to the president of India. However, he has no diplomatic, military or emergency powers like the president. The powers and functions of the governor can be studied under the following heads: executive powers, legislative powers, financial powers and judicial powers. Executive powers. The executive powers and functions of the governor are: all executive actions of the government of a state are formally taken in his name. He can make rules specifying the manner in which the orders and other instruments made and executed in his name shall be authenticated. He can make rules for more convenient transaction of the business of a state government and for the allocation among the ministers of the said business. He appoints the chief minister and the other ministers. They also hold office during his pleasure. There should be a tribal welfare minister in the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha appointed by him. The state of Bihar was excluded from this provision by the 94th Amendment Act of 2006. He appoints the Advocate General of a state and determines his remuneration. The Advocate General holds office during the pleasure of the governor. He appoints the state election commissioner and determines his conditions of service and tenure of office. However, the state election commissioner can be removed only in like manner and on the like grounds as a judge of High Court. He appoints the chairman and members of the State Public Service Commission. However, they can be removed only by the president and not by a governor. He can seek any information relating to the administration of the affairs of the state and proposals for legislation from the chief minister. He can require the chief minister to submit for the consideration of the council of ministers any matter on which a decision has been taken by a minister but which has not been considered by the council. He can recommend the imposition of constitutional emergency in a state to the president. During the period of president's rule in a state, the governor enjoys extensive executive powers as an agent of the president. He acts as the chancellor of universities in the state. He also appoints the vice chancellors of universities in the states. फिर सेंट्रल यूनिवर्सिटीज़ में वाइस चांसलर को कौन अपॉइंट करेगा? ये प्रेसिडेंट करेगा क्या? ये तो मेंशन नहीं था प्रेसिडेंट वाला जो चैप्टर हमने पढ़ा. Legislative powers. A governor is an integral part of the state legislature. In that capacity, he has the following legislative powers and functions. He can summon or prorogue the state legislature and dissolve the state legislative assembly. He can address the state legislature at the commencement of the first session after each general election and the first session of each year. He can send messages to the house or houses of the state legislature with respect to a bill pending in the legislature or otherwise. He can appoint any member of the state legislative assembly to preside over its proceedings when the offices of both the speaker and the deputy speaker fall vacant. Similarly, he can appoint any members of the state legislature council to preside over its proceedings when the offices of both chairman and deputy chairman fall vacant. He nominates 1/6 of the members of the state legislative council from amongst persons having special knowledge or practical experience in literature, science, art, cooperative movement and social service. He can nominate one member to the state legislature assembly from the Anglo-Indian community. He decides on the question of disqualification of members of the state legislature in consultation with the election commission. When a bill is sent to the governor after it is passed by state legislature, he can give his assent to the bill or withhold his assent to the bill or return the bill if it is not a money bill for reconsideration of the state legislature. However, if the bill is passed again by the state legislature with or without amendments, the governor has to give his assent to the bill or reserve the bill for the consideration of the president. In one case, such reservation is obligatory, that is, where the bill passed by the state legislature endangers the position of the state high court. In addition, the governor can also reserve the bill if it is of the following nature: ultra vires, that is, against the provisions of the constitution, opposed to the directive principles of state policy, against the larger interest of the country, of grave national importance, dealing with compulsory acquisition of property under Article व्हाट, सो आई थिंक कुछ मिसिंग हो गया यहाँ पर. 9. He can promulgate ordinances when the state legislature is not in session. These ordinances must be approved by the state legislature within 6 weeks from its reassembly. He can also withdraw an ordinance anytime. This is the most important legislative power of the governor. He lays the reports of the State Finance Commission, the State Public Service Commission, and the Comptroller and Auditor General relating to the accounts of the state before the state legislature. Financial powers. The financial powers and functions of the governor are: he sees that the annual financial statement, state budget is laid before the state legislature. Money bills can be introduced in the state legislature only with his prior recommendation. No demand for a grant can be made except on his recommendation. He can make advances out of the contingency fund of the state to meet any unforeseen expenditure. He constitutes a finance commission after every 5 years to review the financial position of the panchayats and the municipalities. Judicial powers. The judicial powers and functions of the governor are: he can grant pardons, reprieves, respites, and remissions of punishment, or suspend, remit, and commute the sentence of any person convicted of any offence against any law relating to a matter to which the executive power of the state extends. He is consulted by the President while appointing the judges of the concerned state high court. He makes appointments, postings, and promotions of the district judges in consultation with the state high court. He also appoints persons to the judicial service of the state other than district judges in consultation with the state high court and the State Public Service Commission. Now we will study in detail the three important powers of the governor: veto power, ordinance making power, and pardoning power, by comparing them with that of president. तो with regard to ordinary bills, ये हो रहा है प्रेसिडेंट की बात कि every ordinary bill after it is passed by both the house of the parliament either singly or at a joint sitting is presented to the president for his assent. He has three alternatives. He may give his assent to the bill. The bill then becomes an act. He may withhold his assent to the bill. The bill then ends and does not become an act. He may return the bill for reconsideration of the houses. If the bill is passed by both the houses again with or without amendments and presented to the president for his assent, the president must give his assent to the bill. Thus the president enjoys only a suspensive veto. अब गवर्नर की देखते हैं. एवरी ऑर्डिनरी बिल आफ्टर इट इज पास्ड बाय द लेजिस्लेटिव असेंबली in case of a unicameral legislature or by both the houses in case of a bicameral legislature, either in the first instance or in the second instance, is presented to the governor of his for his assent. He has four alternatives. He may give his assent to the, तो यहाँ पर 3 था, यहाँ पर 4 एक्स्ट्रा क्या है देख लो. He may reserve the bill for the consideration of the president. ये एक्स्ट्रा है, बाकी कुछ नहीं है. तो ऐसे लिख सकते, बेकार में रिपीट किया ना. When a state bill is reserved by the governor for the consideration of the president has three alternatives. वही सेम बात. He may give his assent to the bill then becomes an act. He may withhold his assent, he may return the bill. तो उससे वही बात है, ठीक है, फालतू के. चलो इधर देखते. बट यहाँ पर देखो सी वाला अलग है कि ही मे रिटर्न द बिल फॉर रिकॉन्सिडरेशन ऑफ द हाउस. ओके, व्हेन अ बिल इज सो रिटर्न द हाउस और हैव टू रिकॉन्सिडर इट विदिन 6 months. If the bill is passed by the house or houses again without amendments and presented to the president for his assent, the president is not bound to give his assent to the bill. He may give his assent to such a bill or withhold his assent. तो ये वाला अलग है. एवरी मनी बिल, अच्छा इसको बाद में पढ़ते हैं. तो ये वाला देख लेते हैं गवर्नर का. When the governor reserves a bill for the consideration of the president, he will not have any further role in the enactment of the bill. If the bill is returned by the president for the reconsideration of the house or houses and is passed again, the bill must be presented again for the presidential assent only. If the president gives his assent to the bill, it becomes an act. This means that the assent of the governor is no longer required. Now, every money bill after it is passed by the parliament is presented to the president for his assent. He has two alternatives. He may give his assent to the bill then becomes an act. He may withhold his assent to the bill, क्योंकि पहले से अप्रूवल लिया जाता है, तो withhold his assent to the bill then ends and does not become an act. And गवर्नर की बात करें, एवरी मनी बिल आफ्टर इट इज पास्ड बाय द स्टेट लेजिस्लेचर यूनिकैमरल और बाइकैमरल इज प्रेजेंटेड टू द गवर्नर फॉर हिज असेंट. ही हैज थ्री alternatives. He may give his assent to the bill becomes an act. He may withhold. थर्ड एक्स्ट्रा है, he may reserve the bill for the consideration of the president. Thus, the president cannot return a money bill for the reconsideration of the parliament. Normally, the president gives his assent to a money bill as it is introduced in the parliament with his previous permission. When a money bill is reserved by the governor for the consideration of the president has two alternatives. He may give his assent to the bill then becomes act. He may withhold his assent to the bill then ends and does not become an act. Thus, the president cannot return a money bill for the reconsideration of the state legislature as in the case of the parliament. Okay. Now इधर देखिए, every money bill after इधर पढ़ा. Thus the governor cannot return a money bill for the reconsideration of the state legislature. Same. Normally the governor gives his assent to a money bill as it is introduced in the state legislature with his previous permission. Same. When the governor reserves a money bill for the consideration of the president, he will say ये extra है, he will not have any further role in the enactment of the bill. If the president gives his assent to the bill, it becomes an act. This means that the assent of the governor is no longer required. ठीक है. Comparing ordinance making power of the president and governor. So president, he can promulgate an ordinance only when both the house of parliament are not in session or when either of the two houses of the parliament is not in session. The second provision implies that an ordinance can also be promulgated by the president when only one house is in session, because a law can be passed by both the houses and not by one house alone. Governor की बात करें, he can promulgate an ordinance only when the legislative assembly in case of a unicameral legislature is not in session, or in case of a bicameral legislature when both the houses of the state legislature are not in session, or when either of the two houses of the state legislature is not in session. The last provision implies that an ordinance can be promulgated by the governor when only one house in case of a bicameral legislature is in session, because a law can be passed by both the houses and not by one house alone. He can promulgate an ordinance only when he is satisfied that circumstances exist which render it necessary for him to take immediate action. President की बात हो रहा है और गवर्नर भी सेम ही है. He can promulgate an ordinance only when he is satisfied that circumstances exist which render it necessary for him to take immediate action. Then देखो President, his ordinance making power is coextensive with the legislative power of the parliament. This means that he can issue ordinances only on those subjects on which the parliament can make laws. And governor की बात करें, his ordinance making power is coextensive with the legislative power of the state legislature. This means that he can issue ordinances only on those subjects on which the state legislature can make laws. An ordinance issued by president has the same force and effect as an act of the parliament. An ordinance issued by governor has the same force and effect as an act of the state legislature. An ordinance issued by president is subject to the same limitations as an act of parliament. This means that an ordinance issued by him will be invalid to the extent it makes any provisions which the parliament cannot make, that is judicial power. An ordinance issued by him is subject to the same limitations as an act of the state legislature. This means that an ordinance issued by him will be invalid to the extent it makes any provision which the state legislature cannot make. Now, president cannot withdraw an ordinance at any time, can withdraw an ordinance anytime, and governor भी same ही है. Then president, his ordinance making power is not a discretionary power. This means that he can promulgate or withdraw an ordinance only on the advice of the council of ministers or of ministers headed by the prime minister. इसका advice लेना पड़ेगा ordinance जारी करने के लिए. His ordinance making power किसका एडवाइस लेगा? ये काउंसिल ऑफ मिनिस्टर्स का. और गवर्नर का भी सेम ही है. दिस मीन्स दैट ही कैन प्रोमलगेट और विथड्रॉ एन ऑर्डिनेंस ओनली ऑन द एडवाइस ऑफ द काउंसिल हेडेड बाय द चीफ मिनिस्टर. An ordinance issued by president should be laid before both the house of parliament when it reassembles. An ordinance issued by governor should be laid before the legislative assembly or both the houses of the state legislature when it reassembles. Same ही है. And ordinance issued by president ceases to operate on the expiry of 6 weeks from the reassembly of parliament. It may cease to operate even earlier than the prescribed 6 weeks. if both the houses of parliament passes resolutions disapproving it. An ordinance issued by him ceases to operate on the expiry of 6 weeks from the reassembly of the state legislature. It may cease to operate even earlier than the prescribed 6 weeks if a resolution disapproving it is passed by the legislative assembly and is agreed to by the legislative council in case of a bicameral legislature. He needs no instruction for making an ordinance, and he cannot make an ordinance without the instruction from the president in 3 cases. तो ये वाला पॉइंट इंपॉर्टेंट है कि प्रेसिडेंट को कोई इंस्ट्रक्शंस की ज़रूरत नहीं है, बट गवर्नर के इंस्ट्रक्शन की ज़रूरत है 3 केस में. इफ़ अ बिल कॉन्टेनिंग द सेम प्रोविजन वुड हैव रिक्वायर्ड द प्रीवियस सैंक्शन ऑफ द प्रेसिडेंट फॉर इट्स री इंट्रोडक्शन into the state legislature, if he would have deemed it necessary to reserve a bill containing the same provision for the consideration of the president, if an act of the state legislature containing the same provisions would have been invalid without receiving the president's assent. Comparing pardoning powers of president and governor. So president can pardon, reprieve, respite, remit, suspend or commute the punishment or sentence of any person convicted of any offense against a central law. Then governor, he can, वही बात है, punishment person any against a state law. तो state law देखती है governor और central law देखते हैं president. Now president can pardon, reprieve, respite, remit, suspend or commute a death sentence. He is the only authority to pardon a death sentence. A governor cannot pardon a death sentence. So ये वाला बहुत important है. Even a state law prescribes for death sentence, the power to grant pardon lies with the president and not the governor, but the governor can suspend, remit or commute a death sentence. He can grant pardon, the president, reprieve, respite, suspension, remission or commutation in respect to punishment or sentence by a court martial, military court, and governor does not possess any such power. ठीक है, तो गवर्नर थोड़ा लेस पावर दिया गया गवर्नर को. नाउ कॉन्स्टिट्यूशनल पोजीशन ऑफ गवर्नर. द कॉन्स्टिट्यूशन ऑफ इंडिया प्रोवाइड्स फॉर ए पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट इन द स्टेट्स एज इन द सेंटर. Consequently, the governor has been made only a nominal executive. The real executive constitutes the council of ministers headed by the chief minister. In other words, the governor has to exercise his powers and functions with the aid and advice of the council of ministers headed by the chief minister, except in matters in which he is required to act in his discretion, that is without the advice of ministers. In estimating the constitutional position of the governor, particular reference has to be made to the provisions of articles 154, 163 and 164. These are the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this constitution. ये आर्टिकल 154 में है. There shall be a council of ministers with the chief minister as the head to aid and advise the governor in the exercise of his functions, except in so far as he is required to exercise his functions in his discretion. Article 163. The council of ministers shall be collectively responsible to the legislative assembly of the state. Article 164. This provision is the foundation of the parliamentary system of government in the state. From the above, it is clear that constitutional position of the governor differs from that of the president in the following 2 respects. While the constitution envisages the possibility of the governor acting at times in his discretion, no such possibility has been envisaged for the president. अच्छा, the governor acting at times in his discretion, no such possibility has been envisaged for the president. President को हमेशा ही एडवाइस लेना पड़ेगा, बट कुछ प्रोविजंस ऐसा भी है जहाँ पर गवर्नर को काउंसिल की एडवाइस नहीं लेना पड़ता. आफ्टर द 42nd Amendment Act 1976, ministerial advice has been made binding on the president, but no such provision has been made with respect to the governor. यहाँ पर तो ज़्यादा फ्रीडम है भाई गवर्नर का. The constitution makes it clear, बट क्यों किया गया? क्योंकि ये जो मिनिस्ट्रियल एडवाइस होगा ये स्टेट का होगा, इसलिए ये बाउंड नहीं है. ठीक है, क्योंकि ये तो भाई सेंट्रल का एजेंट है. दैट्स वाई the constitution makes it clear that if any question arises whether a matter falls within the governor's discretion or not, the decision of the governor is final. अच्छा, गवर्नर ही फाइनल करेगा. And the validity of anything done by him cannot be called in question on the ground that he ought or ought not to have acted in his discretion. क्वेश्चन भी नहीं कर सकते. The governor has constitutional discretion in the following cases: reservation of a bill for the consideration of the president, recommendation for the imposition of the president's rule in the state, while exercising his functions as the administrator of an adjoining union territory in case of additional charge, determining the amount payable by the government of Assam, Meghalaya, Tripura and Mizoram to the autonomous tribal district council as royalty accruing from license for mineral exploration, seeking information from the chief minister with regard to the administrative and legislative matters of the state. In addition to the above constitutional discretion, that is the express discretion mentioned in the constitution, the governor, like the president, also has situational discretion, the hidden discretion derived from the exigencies of a prevailing political situation in the following cases: appointment of chief minister when no party has a clear cut majority in the state legislative assembly, or when the chief minister in office dies suddenly and there is no obvious successor; dismissal of the council of ministers when it cannot prove the confidence of the state legislative assembly; dissolution of the state legislative assembly if the council of ministers has lost its majority। आई थिंक यहाँ पर ये चैप्टर खत्म होता है। ये सारे आर्टिकल्स के बारे में हम अभी बाद में पढ़ेंगे, अभी भी है। मोरोवर द गवर्नर हैज सर्टेन स्पेशल रेस्पॉन्सिबिलिटीज टू डिस्चार्ज अकॉर्डिंग टू द डायरेक्शंस issued by the president. In this regard, the governor, though has to consult the council of ministers led by the chief ministers, acts finally on his discretion. They are as follows: Maharashtra, establishment of separate development boards for Vidarbha and Marathwada; Gujarat, establishment of separate development boards for Saurashtra and Kutch; Nagaland, with respect to law and order in the state for so long as the internal disturbance in the Naga Hills, then Tuensang area continues; Assam, with respect to the administration of tribal areas; Manipur, regarding the administration of the hill areas in the state; Sikkim, for peace and for ensuring social and economic advancement of the different sections of the population; Arunachal Pradesh, with respect to law and order in the state; Karnataka, establishment of a separate development board for Hyderabad Karnataka region. Thus, the constitution has assigned a dual role to the office of a governor in the Indian federal system. He is the constitutional head of the state as well as the representative of the center, that is president. तो यहाँ पर चैप्टर ख़त्म होता है। तो हमारे इसी के साथ हमारा पहला दिन का ये टारगेट दिया गया था। तीनों चैप्टर और भी पढ़ने की कोशिश करेंगे क्योंकि जल्दी ख़त्म करना है इस बुक को, ठीक है। तो इस वीडियो में इतना ही। हम बाकी टारगेट को नोट डाउन करते हैं और नेक्स्ट दिन से हम पूरा मतलब एक दिन का टारगेट, मान लो पॉलिटी का टारगेट है तो वो एक ही वीडियो में हम कवर करेंगे कोई कोशिश ये सब छोड़ो, हो ही नहीं रहा, ठीक है। थैंक यू, थैंक्स फॉर वॉचिंग।